All right, we will be speaking about the protest groups that have been pushing for this licensing right to be set aside. So we'll be speaking in just a moment to Sinegugu Zukulu. He is the program manager for a lobby group. They're called Sustaining the Wild Coast. So he lives within the Pondoland Marine Protected Area along the Eastern Cape's Wild Coast. You'd know that a lot of community members were against the deal to begin with because of how they felt it would impact their environment and their livelihoods. A very good evening to you, Mr. Zukulu. So
good evening, Chairperson.
The judge ruling that it was illegal, the government's decision to allow Shell to shoot seismic off the country's south coast. What do you anticipate that the fallout will be from this? Because people obviously have had different reactions. You obviously, as the environment groups, would have had your own breath of, or should I say, sigh of relief. Share with us your thoughts. What would be the anticipated fallout?
We definitely do welcome the ruling because it affirms what we have said all along, that this permit given by the department to Shell to do the seismic exploration along the Wild Coast is illegal for the various reasons that we raised. One, for the non-consultation with us as coastal communities who are dependent on the ocean for livelihood and for religious practices. It is also wrong if we are looking at a global scale in terms of climate change. Therefore, we are vindicated and we welcome this judgment. But of course, we are worried about the fact that our government, our very own government that we have voted into power, is not willing to listen and to engage with us. The very fact that they were able to go ahead and give Shell the permit to go and explore without recognizing the fact that we have got the legal and the constitutional right to be consulted about that which is going to affect our lives and our livelihood. So it is very concerning. Even when an alarm was raised, the Minister for Minerals and Energy, Mineral Resources, decided not again to come to the people, but instead went around speaking to the traditional leaders, knowing quite well that in the traditional African customary system, traditional leaders do not make decisions on behalf of the people, but the people make the decisions. It's a bottom-up process whereby they inform and give the mandate to traditional leaders. But up until now, no effort has been made, despite the outcry. Leaving us, therefore, with no option but to use courts of law. That's very unfortunate for our democracy in this country.
I mean, we'll get to various aspects of what would have been endangered, but looking at part of your legal action, I mean, you were arguing that the awarding of the exploration right, the decision makers failed to consider the Integrated Management, Coastal Management Act and its requirement on what you said, consider the interests of the entire community, including the fishes and the ocean life. But I'm wondering, should there be changes to the law itself, or was it the interpretation thereof that led to the situation?
Yes, it was very clear, even in court during the argument, that the understanding and the interpretation of the law was very, very different from those. So we were there for the 2 days that the matter was being argued on the 30th and 31st of May. It was very clear that the interpretation, given the fact that the law changed in 2014, so it was clear that there was some very different interpretation in terms of what should have happened, because since the law changed and they didn't use the permit they were given before the law changed, they came back and reapplied and then renewed again last year. So they should have complied with the new regulation. So in their opinion, that was not the case. But of course, the court has decided otherwise.
I mean, one of the objectives of the ICMA is to introduce an integrated approach to management, and in this instance, it was the decision maker that did not did the quite opposite in dealing with the application as an energy sector specific issue. But I'm just wondering, as the wider industry, what will be the impact of this in terms of exploration, the sector?
Yes, in terms of what the marine biologists, which we had more than, I think, the class 5, whom we have, who wrote the affidavit to support us in our case, made it very clear that the evidence in the recent years has shown clearly that the exploration, the seismic exploration, does impact on the quantity of fish. In countries such as Namibia, the recent studies done there along the west coast, you had cases where tuna fish declined by almost 60 to 70% due to the seismic exploration. So the evidence is overwhelming, and when the license was given, it was based, though the permit was given to them last year, but they were basing it on the old studies, not on the latest. Hence, in the judgment, it's very clear that when permits they are given, it has got to be based on the latest research and scientific evidence, which was not the case. So it is, as you say, an integrated approach is very important to be looking at both what the science is telling us and what the perceived impact is going to be on the marine life, on the lives of the people, and looking in particular into the rights and the livelihood. So one of the things we're raising was that this particular decision by government to give Shell this didn't look at what is at stake when it comes to the livelihoods of those coastal communities. And it is very important that when decisions on development they are taken, they should take into consideration on the impact on the environment and on the livelihoods of those people who are dependent on that particular environment.
I mean, some of this is a bit technical for us. For instance, I mean, the decision on granting the exploration right apparently falls, the review should be under Section 6.2 of the Promotion of Administrative Justice Act. But I just want to understand, in relation to climate change, what should have been considered, what would have been ideal, particularly in terms of the right to food. According to the judgment, the decision maker had the benefit of considering a comprehensive assessment of this and the need and desirability of exploring for new oil and gas reserves, but didn't do this.
You see, the very fact that we were just barely a month away from the last conference of parties of UNFCCC on the climate change conference, where the consensus is that the CO2 or the fossil fuels and emission are causing climate change. And we've seen with the recent floods, for instance, that climate change impacts mainly affect the most vulnerable are the rural people, are the poor people. We have seen with the recent floods exactly the number of people who died, that were mainly the poor. So therefore, allowing a country like South Africa, allowing an energy giant and a multinational corporation like Shell to go ahead in the face of climate change to explore further for oil and gas, after they've recently lost a major court case again in Netherlands last year, where the order of the court was that they should reduce their emission by something like 40%. It is wrong, and it is wrong because the poor are the ones who are more vulnerable, who are never able to be bounced back. But those people who are the shareholders, who live in who are well off. They are able to bounce back. They've got insurances.
Sinegugu, unfortunately, I do apologize for cutting you off, but we have run out of time completely, and I really appreciate you taking the time to just unpack that for us. Sinegugu Zukulu is with Sustaining the Wild Coast Program Manager Lobby Group. We're going to leave it there for now.